We left off with jurisdiction, the different types of jurisdiction. Now, the book goes in detail onto each different types of jurisdiction. From page 57 to page 63 covers the various types of jurisdiction. I'm going to briefly run through them, and I tell you even better, the book on page, which will go in detail, the book on page 63 goes over each one. This 63 is the important page. But before we get there, let's just skim through each of the various forms of what jurisdiction is and how they operate. Once again, jurisdiction is the court's ability to render a decision on a particular item. We have a federal system here in the United States. What do I mean by that? We have 50 states here in the United States that make up the United States of America. Usually what happens, let's say you're living here and you want to sue your neighbor, you don't go sue them up in a court system in, let's say, for example, Maryland. No, you sue them in a court system here. More specifically, since we're here in Miramar, you sue them in a court system here in Broward County. You don't go all the way to a various county, let's say in the state of Maine or California, to sue your neighbor here, you know. Now, sometimes it gets a little bit more complex than that, and we'll go over some of those complexities. But before we get to that, let's just talk about each of those items. The book notes first, jurisdiction over persons or property. There's in personam jurisdiction, which is jurisdiction over the person. And then there's in rem jurisdiction, jurisdiction over the thing. So for example, if you're suing your neighbor, well, you're suing the person. Jurisdiction rests with the person. Now, if you're suing, let's say, for example, somebody who hit your car or stole your car and your car is here in Florida, most likely you'll sue them here. Now, if you're traveling and let's say you get into an accident up in Virginia or your car gets stolen in Virginia, more likely than not, the jurisdiction over the item, over the action rests up in Virginia. But jurisdiction over the person in personam jurisdiction and jurisdiction over the thing, whether or not a stolen item or an accident, for example. Now, long-arm statutes. Long-arm statutes are a little bit more difficult, but a long-arm statute works when the court system tries to grab, essentially, a person in another court system. The book has an excellent example, so let me just read through it real quick to help you understand what a long-arm statute is. Case in point, we're on page 57, and it says case in point under long-arm statutes. An Xbox game system caught fire in Bonnie Broquet's home in Texas and caused substantial personal injuries. Broquet filed a lawsuit in a Texas court against Jai Hall Industrial Company, a non-resident company. Non-resident, what do they mean? That they're not actually headquartered in the state of Texas, that made the Xbox components. Broquet alleged that Jai Hall's components were defective and had caused fire. Jai Hall argued that the Texas court lacked jurisdiction over it, but a state appellate court held that Texas long-arm statute authorized the exercise of jurisdiction over the out-of-state defendant. Why? Because the site of the element happened here, and so the state can stretch out its long arm and force that company to come make a decision here and come defend themselves here in the state of Texas. Corporate contacts. Because corporations are considered legal persons, courts use the same principles to determine whether it is fair to exercise jurisdiction over a corporation. A corporation normally is subject to personal jurisdiction in the state in which it is incorporated, has its principal office, and or is doing business. Courts apply the minimum contacts test to determine if they can exercise jurisdiction over an out-of-state corporation. Minimum contacts requirement is usually met if the corporation advertises or sells its products within the state or places goods into the stream of commerce with the intent that the goods be sold in the state. I want to touch on the stream of commerce real quick. It's an ancient sort of element here in the United States, if we can call anything ancient here. Really, I guess the United States isn't that old as a form of government when you look at some of the other ones. But it's an old form. Commerce, or at least the federal government's ability to work over commerce. In commerce, what do I mean? Trade, exchanging of goods and services. The federal government had the ability to regulate commerce in between the states. And more often than not, this actually resulted in the U.S. government conducting or allowing trade in between states, for example, let's say New York and New Jersey, over the Hudson River, for example, an actual river. So the stream of commerce is actually an older term, sort of referencing the federal government's ability to control commerce and trade over rivers. The idea is seeming trade was often connected with rivers. It isn't so much anymore, as we have highways and all these things and stuff like that, but the stream of commerce is actually an older term. But let's keep on going. Suppose that a business is incorporated under the laws of Maine, but has a branch office and manufacturing plant in Georgia. The corporation also advertises and sells its products in Georgia. These activities would likely constitute sufficient context within the state of Georgia to allow Georgia court to exercise jurisdiction over the corporation. Some corporations, however, do not sell or advertise products or place any goods in the stream of commerce. Determining what constitutes minimum context in these situations can be more difficult. Now, they have a valuable case, and we'll go over the case in class together. But one thing is, and it's interesting, and I want you to think about as well, what happens when you're advertising stuff over the internet? Does that constitute advertising everywhere just because you can access something over the internet? It may or may not in different instances, and we're going to find out more as we talk about it in class, especially with this case. On to page 60, jurisdiction over the subject matter. The courts have what's called general and limited jurisdiction. They have original and appellate jurisdiction. Now, how does it work? For example, we have a layered system here. The Supreme Court usually doesn't hear cases first. It usually has to pass through our court system. And we even have different sort of courts here. We have some courts that are called probate courts. Probate courts deal if somebody dies and what happens to all their assets. We have a bankruptcy court, which is separate, that deals when somebody goes bankrupt here in the United States. And we have our normal court systems where two people are suing each other. Those are called general jurisdiction. Meaning if you want to sue somebody, you usually don't go to probate court. But if you're dealing with, say, you had an old relative that died, then you will go ahead and most likely go to probate court. I have a fascinating case with probate court I'll talk about in class. Make sure to remind me about that as well. Original and appellate jurisdiction. Now, sometimes if a judge renders a decision on your case and you don't like that decision, well, you can appeal it to the next higher court, and we'll go over the various levels of court systems. The jurisdiction of the federal courts. Like I said, the United States is a federalized system. What do I mean? We have states that make up the United States. So each state has its own court system, and the United States has its own court system. We'll have a perfect picture of that drawn later on, but the United States courts have to have what's called federal questions involved, and also diversity of citizenship. I encourage you to read more on those as well. We have exclusive versus concurrent jurisdiction. But I want to actually go into, and make sure to read those as well, but jurisdiction in cyberspace. This is the extremely important one. A lot of business now is done over the internet. Companies they'll have storefronts, but a lot of business is done by purchasing things online. Huge companies have made a lot of money by buying and selling things online. Amazon.com, for example. Jurisdiction in cyberspace. The internet's capacity to bypass political and geographic boundaries undercuts the traditional basis on which courts assert personal jurisdiction. The basis includes a party's contacts with a court's geographic jurisdiction. As already discussed, for a court to compel a defendant to come before it, there must be at least minimum contacts and the presence of a salesperson within the state. For example, are there sufficient minimum contacts if only the connection to a jurisdiction is on an ad on a web page or website originating from a remote location? That's what I'm talking about. Are you, in fact, you have a business that sells shoes in the state of New Jersey and you advertise online. Are you, in fact, doing business all over the world? Do you have what's called substantial contacts or even minimal contacts in every state or in every place in the world just because you placed an ad online? The sliding scale standard. Gradually, the courts are developing a standard called a sliding scale standard for determining when the exercise of personal jurisdiction over an out-of-state internet-based defendant is proper. In developing this standard, the courts have identified three types of internet businesses, three types of internet contacts. One is substantial business conducted over the internet, with contracts and sales, for example. Two, some interactivity through a website. And three, passive advertising. Jurisdiction is proper for the first category, is improper for the third, and may or may not be appropriate for the second. And internet communication is typically considered passive if you have to voluntarily access it, considered passive if people have to voluntarily access it to read the message, and active if it is sent to a specific individual. In certain situations, even a single contact can satisfy minimal contacts requirements. So basically what happens, if you're direct emailing somebody, I'm emailing you my services. It happens a lot as I'm an attorney. I receive emails from companies that want to offer mail services, companies that want to offer, hey, I can be an expert witness in your trial. Those guys are substantial business conducted over the internet. Those are the guys that are emailing you directly. Now, if I'm just going through the internet and I pass several ads, those are what's called passive ones. Now, the gray area is some interactivity through a website. Now, that's going to be hard, and that's stuff that we'll work on together. We'll talk about the case in point as well as we go on to another one. International jurisdictional issues. This one's fantastic. International jurisdiction, especially when it comes to big companies like Yahoo, like Amazon, and things like that. In some countries, and the book talks about a great case, in some countries it's illegal to advertise certain materials. For example, one is you cannot advertise, and the book talks about it, Nazi material, Nazi books, Nazi articles in the country of France. Germany as well, to be honest, as I believe. Now what happens is Amazon.com, Yahoo, they have various articles that cover, Nazi history or things like that people can buy and purchase for whatever various reasons. I mean, some people want to buy these things for historical purposes. But regardless, in the United States, we have pretty open laws about freedom of speech, regardless of any of our moral opinions on whether you should be buying a book on the Nazis anyway to begin with. But anyway, in France, it's illegal. You actually can't advertise to sell Nazi literature, a book about the Nazis, a historical book, a history book, for example. So, how does it work? Yahoo, as we can see in the book, operated an online auction site on which Nazi memorabilia, among other things, were offered for sale. France sued Yahoo to stop. The French court agreed, as it's illegal to do that in France, and they won. The United States, Yahoo then filed a case here in the United States to try to overrule the French court system by saying it violates the United States First Amendment laws, which is true, but how it operated is the U.S. court system eventually ruled that that this decision lies in France, as the business is being conducted in France, and these are the people that are having the problems in France, and as such is outside the jurisdiction of the U.S. court to decide French law. Pretty neat. Now, I was talking about page 63. This is an important page. This goes over personal property, subject matter original, appellate, federal, concurrent, exclusive, and jurisdiction in cyberspace, and it outlines each one. These are the sort of pages when it's coming for your midterm to pay attention to go back and to look on, because this is a great study guide for you on the midterm. But let's talk about venue real quick. Jurisdiction has to do whether a court has an authority to hear a case involving a specific person's property or subject matter. Venue is concerned with the most appropriate location for trial. For example, sometimes multiple courts may have jurisdiction over the same sort of item. But there's usually one proper venue for this case to be heard. Now, sometimes, sorry, my nose is itching in a minute. Sometimes people will have to file for a change of venue. This happens a lot of time in family law cases. For example, if you're getting divorced from your spouse, unfortunately, and you own a house in an area and your spouse wants to, let's say you guys lived here in Florida, but your spouse wants to file for a divorce, I don't know, you guys live down here in Broward, they want to file in Pensacola, which is on the north part of Florida. Proper venue, most likely, even though the person technically could file in Pensacola, proper venue is probably here in Broward because the family's here, the house is here, and all those other items. That's what they're talking about. Even though a court in Pensacola could hear the case, the proper venue is here. Standing to sue. Standing to sue is an interesting element, and if when you read that case online that I'm going to post, the one that mentions my article, that actually talks about standing. Now, what is standing? Standing is your ability to go before the court. Let's say you own a business and you want to sue some guy who breached a contract with you. You know what? Your cousin hates the fact that you haven't sued yet, and your cousin wants to go and sue on your behalf. Your cousin doesn't have standing. It's not his business. Even though he feels affronted on that element, it's you who has to sue. Not somebody that you know that feels bad for you that wants to sue for you because you don't want to. I'm going to talk about more of this, and we'll work through it as in our group section. But standing to sue is the person who is aggrieved. That's the person who has to bring about the challenge, not somebody else. Now you can hire attorneys, of course, that has nothing to do with standing, but I'm talking about the actual individual who files the sort of element. On page 66 is what I was talking about with the chart of the system. You'll see it here, but it works where it talks about the different levels of court. On the one side, on our right-hand side, you have local trial or courts of limited jurisdiction. For example, the various items. Then we have a straight trial courts or general jurisdictions, state courts of appeal, and the highest state courts of appeal. On the left-hand side, we have all of our various court systems here in the U.S. system. U.S. district courts, specialized courts, federal administrative agencies. I mentioned this in our first class, federal administrative agency. If you remember, I mentioned Social Security, but also immigration falls under a federal administrative agency. It's a quasi-judicial agency, which is kind of neat. U.S. Courts of Appeals and U.S. Supreme Courts. Now, the book goes into examples of how each of these various ones work, and we'll go over them together to help work it out, but there is no real need to go too much in depth in the lecture itself because it's pretty self-explanatory from the picture about the various levels. But I encourage you, and you need to, for midterm purposes, to read through each of these items. It talks about the U.S. District Courts, U.S. Courts of Appeals. Pay attention on page 68 also to Exhibit 3.3. You can see the Florida falls into the 11th Circuit. Now, the 11th Circuit, that's for federal appeals. Federal circuit purposes. I won't go into too much about the rest of this, but we'll move in, and I'll take a quick break now again, and we'll move into Section 4, which is alternative dispute resolution.